When a large data center is announced, the press release may include a famous company name. That can make the project sound safe. But a famous name is not the same thing as a public guarantee. Oklahoma needs to know who actually owns the project, who signs the contracts, who pays the bills, and who is responsible if the project changes, stalls, gets sold, or fails. The public question is simple. Who stands behind the promise? If a data center says it will pay for power, water, roads, and other costs, Oklahoma needs to know who is legally responsible. Is it the famous technology company? Is it a developer? Is it a landlord? Is it a separate limited liability company? Or is it some other entity created for this one deal? That answer matters. Large data centers are often built with complex business structures. There may be a developer, a landlord, a tenant, a lender, a power customer, and a special purpose entity. That may be normal business practice, but the public should not have to guess who is responsible. If taxpayers, ratepayers, or local communities carry any risk, the ownership structure should be clear. A limited liability company is not automatically bad. Businesses use them every day, but the word limited matters. It can limit who is responsible if something goes wrong. So Oklahoma should not approve a major project based only on the brand name in the announcement. Officials should ask who signs the agreement, what assets stand behind it, and whether the obligation survives if the project is sold or restructured. HB 2992 says large data centers should pay for the electric costs they create. That is the right principle. But a rule is not the same thing as payment. A tariff does not help if the customer cannot pay. An exit fee does not help if it is too small. A contract does not help if the signer has limited assets. The law works only if a strong party stands behind the bill. The risk is not only that a project fails completely. The risk can also be delay, downsizing, a change in ownership, a change in technology, or a decision to use less power than expected. By then, the utility may already have planned new power lines, substations, or other electric system costs. Somebody still has to pay. That somebody should not be ordinary customers. A data center agreement should not disappear when the project changes hands. If the project is sold, the promises should still apply. If the lease changes, the promises should still apply. If project ownership changes, the promises should still apply. If the financing changes, the promises should still apply. Public obligations should follow the project. They should not vanish in a paperwork shuffle. The public does not need vague assurances. It needs proof of financial strength up front. That may mean a letter of credit, a bond, a strong guarantee, a payment agreement that still applies after new ownership, or another form of protection that makes sure the public is not left paying. The exact tool can vary by project, but the principle should not vary. If the company creates the cost, it must demonstrate the ability to pay. The same rule should apply when a data center asks for public benefits. That could mean a tax break, a land deal, a water deal, road help, or some other public support. Before the public gives anything up, the public deserves proof. What jobs will be created? What taxes will be paid? What costs will be created? What protections are in writing? And what happens if the promises are not kept? The press release is not enough. The public benefit test should come first. Then the signed agreement should put the promises in writing. Who is legally responsible? What costs are covered? What happens if the project changes? And what protection exists if the customer cannot pay? That is what Oklahoma should know before approval. Before approving a large data center, Oklahoma officials should ask clear public questions. Who owns the project? Who signs the agreements? Who pays for power, water, roads, and local costs? Who stands behind the promises? What happens if the project is delayed, downsized, sold, or closed? If those answers are not clear, the project is not ready. Oklahoma can welcome data centers and still protect the public. It can work with major technology companies and still ask who signs the contract. It can support investment and still require real payment security. It can encourage growth and still protect taxpayers, ratepayers, and local communities. That is not anti-business. That is basic accountability. A famous name may open the conversation, but a public guarantee has to close the deal. Read the full 5-part series at wlangdon.substack.com.